The long arm of the law reaching for Reason magazine, the Department of Justice issuing a subpoena demanding Reason turn over information on the identities of 6 users who posted threatening comments about a judge online. The magazine, though, has since deleted the comments from its site, but will not say whether it will comply with the federal order. This comes, by the way, after the Supreme Court's recent decision about Facebook and free speech, where they ruled a Pennsylvania man's violent rant against his wife were actually therapeutic and didn't actually count as actual threats. Joining me now, trial attorney Rachel Self and defense attorney Richard St. Paul. All right, Rachel, you lob threats online. They are words. Are they considered actual threats?
No. Well, there's a legal standard for actual threats. You need to have the intent, the ability, and the likelihood of success with those threats. In this particular case, you had a situation where there were people ranting on the internet that this judge should be fed into a wood chipper. I don't know about you, but every criminal that I have ever had a chance to meet doesn't go to a wood chipper as their first line of attack.
But you have to show intent. And if there is intent to harm somebody, if somebody goes on Facebook or Twitter and says, I'm going to kill the president, you bet they're going to end up in jail. So, I mean, where do you draw the line?
No, look, you have to, their intent, the mens rea. It doesn't have to be the actus rea. Actus rea means the physical act. If you intend to kill somebody, you certainly are taking steps to do it. If you intend to kill them, you may purchase a weapon, for example. You don't have to use it, but you may purchase a weapon. So it's something more than just words, the Supreme Court in the Alanis versus United States said. It's something more than just mere words. It's got to be something, you've got to actually intend on carrying out your actions.
Okay, so then do you think the government actually believes that these people that wanted to throw a judge into a wood chipper saw the wood chipper as an actual weapon?
No, and I don't think that the judge now faints at the side of a wood chipper, right? I mean, there needs to be an inherent threat, an actual ability to carry out the threat. And I think the Department of Justice here knows that there's no conviction available for this, and I think that it would take, even the most obtuse grand jury isn't going to issue an indictment on a charge like this, but somebody's life is going to potentially be completely dissolved by trying to fight charges like this.
Here's the problem, okay? I mean, when the government butts into free speech, you got to wonder, when does it end? And at this point, you know, is the government infringing on our rights, and should the libertarian site turn over these commenters? Because what does it say to the next time somebody makes a loose comment on the internet?
I agree. You have to take a stand, but as Rachel said, the litigation is very expensive, and not everybody can afford that. Now, if we look, this is the federal government, Department of Justice in particular, has done this before with reporters from AP and even right here in Fox, when the DOJ, the Department of Justice, subpoenaed the personal emails of the reporters from those agencies over what they were just doing their job and investigating. So imagine if they're going to do that to reporters in the First Amendment, what they'll do to ordinary citizens. This absolutely has to be fought, and it's absolutely overreaching by the federal government.
And it has such a chilling effect on free speech, and I think the Alanis decision is going to be very helpful in situations like this, because that was an 8-to-1 decision, and that there were very clear, much more violative statements made in that case that didn't even come close to this case, where it really was just hyperbolic statements made. You know, I mean, free speech is so subjective, and how you interpret it is so subjective, and I certainly don't want to give the government permission to start to analyze what's in my thought process, right? I mean, the government's big enough.
Let me just play devil's advocate. Let's say that I'm the victim of someone who is threatening to kill me on Twitter, okay? I'm going to want to know who that person is. I'm going to want cops to talk to this person, do a little background check, and find out if this person's just nuts or if they really do want to carry out this attack. If this website, this magazine, doesn't turn over the information, police can't actually do their due diligence, and therefore I feel like there's somebody out there that's going to come out and try to harm me.
Well, look, we're talking about, you know, a public official, which is a federal judge, versus your individual citizen. So it's quite different. You got to look at a big scenario in terms of who's doing the threat, whether they have the intent or not.
All right, Rachel Self and attorney Richard St. Paul, thank you both for coming on.
Thank you. Good to see you.
Julia.